All right, let's talk about the absolute bedrock of any company. Whether it's a tiny startup or a massive corporation, it all starts with one document, the Memorandum of Association, or the MOA. Think of it as the company's constitution. Today, we're going to take that legal blueprint and break it down piece by piece. So, here's what we're going to cover. First, we'll get a handle on what the MOA actually is, the company's charter. Then, we'll look at the 6 essential pillars that hold it up. After that, we're going to get into the really important legal stuff, this invisible fence called the doctrine of ultra vires. And finally, we'll see how this blueprint isn't totally set in stone. We'll look at how a company can actually change its name, move its office, and even switch up its core purpose. Okay, first things first. What in the world is this Memorandum of Association? And why is everyone always saying it's the most critical document a company has? To put it simply, the MOA is like the company's birth certificate and its official rulebook rolled into one. It literally establishes its existence. It lays out the basic, non-negotiable rules of the game. It tells everybody, shareholders, banks, customers, you name it, exactly who the company is, what it's set up to do, and most importantly, the legal lines it absolutely cannot cross. You know, this quote from a really famous old case just nails it. The MOA does 2 things at once. It's affirmative. It says, here's what we can do, here's our power. But it's also negative. It draws a very clear line in the sand and says, and you can do nothing beyond this line. It's both an engine and a fence. So the MOA isn't just a big wall of text. It's actually built on 6 key pillars, what we call clauses. Each one defines a core part of the company's identity. So let's break them down one by one. And we're going to start with the most basic thing you can think of, its name. But this isn't just about branding. It's about following some very strict legal rules. Yeah, you can't just pick any name you want. There's a whole checklist you have to get through. The name has to tell people the liability status, so it's got to end with limited or private limited. It can't be the same or even sound too much like a company that's already out there. And it can't be offensive or make it seem like you've got some official government connection when you don't. Plus, you can't just use someone else's registered trademark. The whole point is to stop companies from misleading the public. And here's a perfect real-world example from a classic case. A new margarine company wanted to call itself Buttercup Margarine. Problem was, a Buttercup Dairy Co. already existed. The court shut it down, saying the names were so close that people would naturally get confused and think they were the same business. This really shows you the law in action. It's all about preventing confusion. Okay, so besides the name, there are 5 other clauses that build the company's profile. The Registered Office Clause sets the company's legal home state. This is super important because it decides which court system has jurisdiction over the company. Then you have the Objects Clause, and this one is huge. It spells out exactly what the company is in business to do. As we'll see, this sets hard limits on its activities. Next, the Liability Clause tells investors exactly what they're signing up for. Is their liability limited to their shares, or is it unlimited? The Capital Clause lays out the financial structure, the authorized share capital. And finally, the Subscription Clause is basically where the founders sign on the dotted line saying, yes, we want to form this company. Together, these 6 clauses give you the full picture. Okay, we've got the structure. Now, let's talk about that invisible legal fence I mentioned. If you're studying for an exam, you need to highlight this next part. The doctrine of ultra vires. It sounds fancy, but the idea is actually pretty simple. Ultra vires is just Latin for beyond the powers. So, if a company does something that isn't listed in its Objects Clause, it's acting outside of its legal power. That act is considered ultra vires. And believe me, that comes with some major consequences. And the consequences are no joke. An ultra vires act isn't just a simple mistake. It's legally void from the get-go, void ab initio. That means it's like it never happened. Shareholders can go to court and get an injunction to stop it. And here's the kicker for management. Directors can be held personally liable to pay back any company money they spent on it. It's a really powerful doctrine designed to protect a company's investors and creditors. Now pay close attention because this is a classic exam question. There's a huge difference between an act that is ultra vires the company and one that is ultra vires the directors. If it's outside the MOA, ultra vires the company, it's incurable. It's totally void. Even if 100% of the shareholders vote to approve it, it doesn't matter. But if the act is something the company could legally do, but the directors just didn't have the authority to do it, that's ultra vires the directors, and that can be fixed. The shareholders can vote to ratify it, and then the transaction becomes perfectly valid. So after all that, you might be thinking this MOA is carved in granite, but it's not.
The law actually has ways for companies to change it and evolve. Let's start with something straightforward, changing the company's name.
You can't just wake up and change the sign out front. It's a formal process. First, you have to get the shareholders to pass a special resolution. That's a high bar. It usually means you need a 75% majority vote. It shows this is a big deal. Then you need to get the okay from the central government in writing. Once you have both approvals, you file the paperwork with the registrar, and they issue a brand new certificate of incorporation. And it's only when you have that new certificate in hand that the name change is official.
Okay, so what if the company wants to move? Well, how complicated that gets depends entirely on how far they're going. Moving across town is one thing, but moving to a different state? That's a whole different ballgame and requires changing the memorandum itself.
Wow, look at all those steps. This really shows you that changing a company's legal home is a very serious matter. It's not just about packing up desks. You start with that special resolution from shareholders. But then, and this is crucial, you have to deal with your creditors. You either have to pay them off or get their permission for the move. That's to make sure you're not just running away from your debts. After that, you apply to the government, you advertise the move publicly, you tell all the regulators. And only after all that, and after the government is sure nobody's being left in the lurch, will they approve it. The final step is to file that approval in both the old state and the new one.
And now we get to the biggest change of all, altering the objects clause. This is literally changing the entire purpose for which the company was created.
So normally, a company can change its objects with a special resolution. But the rules get way, way stricter if that company has taken money from the public and hasn't used it all yet. And this right here gets to the absolute core of modern investor protection. Think about it. If you invest in a company because they promise to develop new software, they can't just take your money and then decide to open a chain of pizza parlors. The law puts a stop to that with a very strict process. They need a special resolution by postal ballot, they have to publicly explain why they're changing, and here's the most important part. They have to give an exit opportunity. Any shareholder who says, hey, this isn't what I signed up for, has the right to sell their shares back to the company's founders. Changes to the other clauses are also carefully controlled. For example, you can't just force a shareholder to take on more liability. That would fundamentally change the deal they made, so you need their written consent. Changing the capital structure, on the other hand, is usually a bit more straightforward. Things like increasing capital or splitting shares can typically be done with just an ordinary resolution. That's a simple majority vote of over 50%, as long as the company's articles of association allow for it.
So, after all this, what's the big takeaway? Well, the Memorandum of Association is, without a doubt, the company's foundational charter. It sets very firm, legally enforceable limits on what a company can and cannot do, all to protect the people who've put their money into it.
But at the same time, it's also a living document. The law gets that businesses need to change and adapt. So it creates these very strict, very deliberate procedures to allow a company to actually change its own constitution. It lets the company evolve, but only in a way that makes sure its stakeholders are protected every step of the way. And understanding that tension, that balance between being a rigid rulebook and a flexible guide, is really the key to mastering the law on the Memorandum of Association.